Make a start. We've only got an hour this morning. We've got quite a lot to get through. So good morning. Thank you for joining us today. We're talking about employment status, where we are now with a particular focus on the education sector. I'm Sian Jackson. I'm a Principal Associate in the Employment Education team at Mills & Reeve. And today I'm joined by Maya Sagas, who's an Associate in the Employment team. Kevin Lowe, who's heads up our tax team at Mills & Reeve, and Judy Roy, who's another Principal Associate in the Employment Education team. So, as I say, we're here to consider employment status, and there's been a lot of case law, an expensive amount of case law in the area, and particularly over recent years, perhaps fewer changes to legislation. And looking at it quite simply as a topic, there's three categories of status for employment law. So employee, worker and self-employed, and the rights vary depending on an individual status. In contrast, there are only two categories for tax purposes, so an employee and a self-employed person. And again, tax treatment will vary depending on the status in those two categories. Today, we're going to discuss the current context in relation to employment status, so both from a higher education sector perspective, and also just the general context in wider sectors across the society. And the second, we'll talk about current legislation and what that says about employment status. We'll move on to talk about the latest case law. As I said, there's been quite a lot of that, so we'll give you an update as to what the current position is on that. And then Kevin will talk about the employment status in a bit more detail from a tax law perspective. And finally, then we'll give you some practical tips to ensure that you comply with the law in this area. So to make a start, I just wanted to talk about the context that we're looking at this in. And so there's a specific context in relation to the education sector, which you're no doubt all aware of. And this has meant that there's increased scrutiny and pressure in the sector. And this is as a result of casualisation or anti-casualisation being one of the campaigns or four fights that UCU is campaigning for at the moment. And the illustration on the slide at the moment is a UCU illustration, which outlines all of the aspects of this particular campaign. So it's campaigning firstly to end 0 hours contracts generally across the sector. It also is looking to end worker arrangements for teaching staff wholesale and replace them with employment contracts. It also wants to move hourly paid staff, so sessional lecturers or associate lecturers, there are various terms for those categories of workers, to fractional employment contracts, so again moving them from worker status to employment status. It also wants to create open-ended or permanent contracts for researchers, which, as we know, are more likely or often on fixed-term contracts, perhaps linked to funding end dates or funding grants. And it also wants to review the use of hourly paid lecturers, generally in post-92 universities, which has become something that's been frequently used over a number of years. And so there are a high numbered group of staff. And then also it has objections to outsourcing staff. This could be catering staff, it could increasingly be other professional services staff, whether it's to a subsidiary or to a third-party organisation, and it wants those staff to be brought back in-house. And then finally, it wants postgraduate teaching assistants to be given guaranteed hours, and again on employment contracts rather than any worker type arrangement. So there's been a lot of things and discussions that have been going on. So over the past few years, we've been supporting our clients increasingly, both on assessing the status of their workforce and implementing changes in the methods of engagement as needed in order to comply with applicable law, whilst also maintaining the need for flexibility of resource in the sector. And so that's the sector-specific context that we're looking at, but looking wider in terms of the context beyond the sector. Then in 2019, just to give you an indication in terms of some statistics around it, it was reported in The Guardian that the gig economy in Britain, or as it's called, had doubled, and at that point was accounting for 4.7 million workers, or 1 in 10 adults. So really quite significant number of the population. Again, the definition of gig worker could be a separate session in itself, but in a nutshell, the gig economy and zero hours contract has been under scrutiny from recent years. It's been the subject of a lot of press coverage, and the lack of protection was a particular topic that was covered, particularly in the context of the COVID pandemic and the economic climate resulting from that. So there's been a general push, a general pressure for more stable contracts across the economy and enhanced rights for individual workers as a result of that. This has led to several inquiries and reviews which have looked at questioning whether the law is fit for the modern economy currently, and with criticism that the statutory definitions as they currently stand aren't actually fit for purpose. And resulting from that, there's been a series of high-profile cases, particularly in relation to couriers and taxi drivers, Uber, etc. And these have importantly been backed by trade unions, which has given them more motive and more strength in terms of coverage. And there has been increased media interest in businesses exploiting effectively what is headlines as media headlines of vulnerable workers, and this some years ago was Sports Direct, for example, which has represented the increased scrutiny and put pressure on organisations beyond the sector itself. So I'm now going to hand over to Judy, and Judy's going to discuss the current employment law on employment status.
Thank you, Sian, and good morning, everyone. Well, employment status is very much at the core of both employment law and the tax system, because it defines the rights which individuals have and the taxes that both they and the organisation must pay. I'm not going to say anything about tax. Kevin will talk about that later. I'm going to focus on the employment legislation. It has to be said that in the vast majority of cases, it will be clear into which category an individual falls, but there will always be cases around the edges, if you like, where it's necessary to look particularly carefully about the status of an individual. And on that point, we've known for a number of years, but I think it bears repeating, that the label which is attached to an individual in a contract, for instance, isn't definitive. So therefore, it's necessary to make a proper and careful assessment. Under current employment legislation, as Sian said earlier, there are three categories: employees, workers, and the self-employed. Looking at the definitions of those categories in the legislation, there's no definition of self-employment in employment legislation. Effectively, it's somebody who is working but is neither a worker nor an employee. Unhelpfully, there are a number of slightly different definitions in the legislation of employee and worker. Those various definitions are effectively variations of the wording that's in the Employment Rights Act. So I've used that wording for the slide where I've summarised the relevant definitions. Just looking briefly at the definition of employee, that's an individual who works under a contract of employment, and yes, that's a completely circular definition, because it doesn't really take us very far or tell us anything. And the definition of worker is a bit more fulsome. The category of worker includes employees within it, and also people who fall into what you might sometimes hear called the Lim B worker category. They are individuals who are not employees, but they're working under a contract to perform work personally, but not doing it as part of their profession or business. In fact, neither definition takes us very far when trying to identify into which category an individual falls, particularly around those sorts of difficult areas at the edges. And for that reason, both definitions have been subject to substantial analysis by courts and tribunals, and a number of tests have developed to supplement these definitions in the legislation. I'll hand over to Maya shortly, who will talk about the latest case law. And then just moving on to statutory rights. As I mentioned earlier, determining the correct status is crucial because that also determines the legal rights that an individual has. And this is a minimum floor of rights for each category, and it's not possible in the vast majority of cases to agree by means of the contract, for instance, to go below that minimum floor of rights. Employees have the highest level of legal protection, workers are an intermediate category, and the self-employed have the least legal protection. I've put on the slide some examples of the rights which attach to all workers, including employees, and those which attach to employees only. It has to be said that there are a number of important legal rights that attach to all workers, including notably the right not to be subjected to unlawful discrimination and the right to whistleblowing protection, for example. But it has to be said that there are a number of key legal rights that do apply to employees only. And in particular, that's rights that relate to termination. So I'm thinking, for example, of the right not to be unfairly dismissed, the right to statutory redundancy pay, and also the application of the ACAS Code on Disciplinary and Grievance procedures. So just moving on then to the importance of getting the status right. Well, in a sense, it's blindingly obvious in view of the fact that status defines what the legal rights of an individual are. And getting it wrong can lead to a number of difficulties. Fundamentally, a misunderstanding about the status of an individual can mean, for example, that they are treated in the wrong way. So, for example, if an organisation thinks that somebody is an employee, they may therefore believe that they don't have unfair dismissal rights and the ACAS Code doesn't apply, and then deal with termination of their contract in a way which, whilst the organisation may think is proper and reasonable, doesn't actually comply with the legal requirements. And similarly, there's a significant risk of building up a contingent liability that will probably have to be paid at some point if it hasn't been properly recognised, what benefits and pay entitlements an individual should get. I think also in the HE sector, it's particularly worth bearing in mind risks around reputation and also industrial relations issues. As Sian mentioned earlier, there's been a lot in the media around businesses in particular being criticised for not treating staff properly. So there's definitely an area of risk there, and also in industrial relations issues in terms of relationships with the unions, because I think for most universities it would be important to be sure that the position which is being adopted in relation to the status of different categories of staff, that position is legally robust. And then moving on to the possible reform of employment status, there's wide recognition that, as I was saying earlier, the definitions which are set out in the employment legislation aren't entirely satisfactory, as they leave so much to be dealt with in case law, which develops over time, and leaves much more than would be ideal subject to interpretation. And it's obviously particularly significant when we're dealing with status which decides the fundamental rights of individuals. Accordingly, the government undertook a consultation on whether the current 3 categories of legal status are the correct and appropriate categories, and also whether the employment legislation should be amended. The government responded to that consultation in July this year. And the outcome is that the 3 categories, the conclusion is that the 3 categories, employee, worker and self-employed, are the right and appropriate categories and get the balance right between flexibility in the workforce and protection for individuals. It's also recognised in the response that there are actually good grounds for amending the legislation and the definitions of these categories for the reasons that I've just said, but the government has said now is not the time, because it is recognised that if the legislation is changed, whilst that may lead to greater certainty in the long term, the risk is that it leads to additional cost for employers in the short term, and also additional uncertainty whilst the changes bed down. And the government has said that it's not the right time because we're in a time of particular economic difficulty, and therefore adding in that type of uncertainty and cost would not be helpful. So an indication that things may change in the future, but not now. So instead of amending the legislation, what the government has done is issued new guidance on employment status, which can easily be found on the government website. A Google search will take you to it, and also an employment status checklist. So there's no change in the law at the moment, but what the guide does is to provide a sort of neatly packaged summary of the law and the tests that have appeared in the cases. But as the government isn't amending the legislation at the moment, what that does mean is that the extensive case law is going to continue to be extremely important. And on that point, I will hand over to Maya, who is going to talk about the case law and give us an update on that.
Maya, before you start, we've just had a question, Judy, which if you could consider which would workers be entitled to statutory sick pay and statutory maternity pay? And the person's said that they've noted that some organisations give workers these rights and others specifically exclude them.
This is one of those areas where there are slightly different definitions in the relevant regulations and bits of the legislation as to which workers are entitled and which are not. So I mentioned, for instance, on the slide that on the family friendly rights, it's usually for usually for employees, but with some exceptions. So it's probably the case that different employers have looked at their particular arrangements and categorized staff in a different way. So not a completely straightforward answer, I'm afraid, but happy to pick up on that separately if you'd like to explore it further.
Thanks, Judy. Yeah, you're right. There's another definition, isn't it? So for individuals who may or may not qualify.
Unfortunately, it's into that there are varying definitions.
Yes, it depends.
Unhelpful.
Thanks, Judy. Sorry, Maya, carry on.
That's okay, thank you. Good morning, everyone. So we're going to look now at the current case law. So if you can just move this up. Thank you. So what we've seen recently is for lower paid workers, the disputes tend to be over statutory rights, whereas for higher paid workers who often have contractual rights that are more favourable and more generous than the statutory rights, the disputes tend to be over tax status. And again, Kevin will be looking at the tax implications in a moment. But what I'm going to do is look at the case law, specifically looking at worker status. And the first case that we can't avoid is a gig economy case called Uber, which was taken to the Supreme Court last year, and which many of you are probably aware. But just to recap, the claimants were a small group of London-based drivers who agreed to a document that said that Uber was a booking agent, But what was actually happening on the ground was that Uber had quite a lot of control over the drivers through the app. So the drivers had no control over the pricing, they had minimal control over the route that they could take, and so on. So the Supreme Court looked at what was happening on the ground, and they confirmed that, that the drivers were in fact workers. So prior to Uber, traditionally, the courts tended to start answering the question about employment status by looking at the contractual documentation. So the documents that are often drafted by the employer. And what Uber said was that this was the wrong way around, that the statutory definition should be the starting point. And you need to consider what the purpose of the legislation is. So for instance, in the gig economy, if the purpose of the legislation guaranteeing core rights like holiday pay is to protect vulnerable workers, then the employer cannot simply contract out by stating in a document that they are self-employed. So the documents drawn up by the employer are important, but they are only part of the overall picture and should not be the starting point. As we move on to some old case law, even though the starting point has changed, concepts from old case law are still relevant. And this is the case of Sejpal and Roderick Sental, which is the case of an associate dentist at a dental practice. And the Court of Appeal has actually remitted it back to the employment tribunal. But what's important from this case is that it gave us some useful guidance on the right questions to ask when you're applying the statutory test. So for instance, when you're asking the first question, is there a contract? What is the nature of the agreement? You consider mutuality of obligation. When you consider the second question, is there a requirement for personal service? You can consider, can the individual provide a substitute, or do they need to, must it be them? And thirdly, the third question is the individual carrying on a profession or a business? If so, is the other party a client or a customer? Then you consider the concepts such as subordination, the level of control exerted over the individual, or how integrated the individual actually is in the business. So what Sejpal said was that these are not tests in themselves, but are concepts that can be used in order to decide whether or not the statutory definition is met. So if we look at some recent Court of Appeal cases after Uber, we move on to looking at personal performance, which is the second question of the definition. This case in particular looked at the right of substitution, so one of the concepts when considering the statutory test. And this is called Stewart Delivery and Augustine. And again, it's like Uber. Mr. Augustine was a delivery driver working through an app. And the main issue here was that he didn't have an actual right of substitution. He just had a hope that if a slot was released, that somebody might be able to replace him. But if he couldn't get anyone to replace him, he would be he would face a penalty. So there wasn't a genuine right of substitution, and therefore he was considered a worker by the Court of Appeal. Another recent case, this is one from February this past year, looks at whether or not there's a minimum amount of work required for an individual to be considered a worker. Now, this is an interesting one, I think, for the education sector. Mr. Somerville was an occasional member for one of the Nursing and Midwifery Council's Fitness to Practice committees. He had independent contractor status, as stated in his contract, and it was essentially a casual arrangement. So the NMC would provide Mr. Somerville with reasonable notice of a committee hearing, and he could choose whether or not he would sit on the panel. But he could withdraw at any time without any consequences. And if the NMC cancelled a hearing, he would still get paid a certain amount. So he was not obliged to attend, and the NMC was not obliged to provide him with a particular amount of work. So the question in this case was, if these arrangements were casual, did that mean that Mr. Somerville could not be a worker? And what the Court of Appeal determined was there doesn't have to be an overriding mutuality of obligation for someone to be considered a worker. So you need to look at the statutory definition, which states that there's a requirement to provide personal service. And in this case, Mr. Somerville was providing a service. He had no right of substitution, and the NMC was not a client or a customer of his business. So the statutory definition was met, and the Court of Appeal determined that Mr. Somerville was a worker while he was providing that service. So there doesn't need to be an overriding obligation that you will provide that service, but that you are a worker when you are providing that service. So the cases that I've looked at so far really has found in favour of the individual and has established that they have worker status. But there are some other recent cases where the opposite has been found. So the individuals have been found to be self-employed. And this turns predominantly on the question of personal service. So if we look at DPD couriers, they were found to be self-employed because they were essentially franchisees with a genuine right of substitution that could not be unreasonably restricted by DPD. In the case of the Deliveroo cyclists, again, they had no obligation to provide services personally, so it was determined that they were self-employed. The Olympic cyclist case is an interesting one. She's actually a cyclist that was dropped from an Olympic training program. She was found to be self-employed because there was no mutuality of obligation. She didn't provide work and British Cycling did not pay her. So because she was not provided with any work by British Cycling, she was not actually providing services. So this test was not met. So again, she wasn't providing personal services. And the last case is one of, there's about 120 postmasters that went to court stating that they should be considered workers in order to be eligible for holiday pay. And once again, they were considered franchisees who did not provide personal service, so they could not be considered workers. So as a whistle-stop tour of worker status and the current case law, I'm going to hand over now to Kevin, who's going to look at the tax implications from the tax law perspective. Thank you.
Thanks, Maya. Right, everyone, it's your lucky day. You're half an hour into a talk on status and somebody's going to talk to you about tax. So we will try to make this as painless as possible. Just before we get on to some of the status determination, and everything you've heard so far is relevant. And of course, the cases on tax tend to come from the other perspective. It tends to be HMRC trying to prove somebody is, in fact, an employee for tax purposes, rather than somebody who's working trying to prove that they are. So just popping on to the next slide, just before going on to those status questions, I just thought I would highlight whose problem this is, because it depends how you contract. And I'm assuming that most of the people who are listening today are going to be what we might call end users, end clients, who are engaging with individuals or their companies or with an agency to provide people. So the issue of whose problem it is to work out the tax status will depend on who you contract with and how they indeed conduct their own affairs down that line. So the easy one first, if you're contracting with an individual direct, it is up to you to determine the tax status. It always has been. It's up to you to decide whether that person should be on the payroll or be off payroll. The IR35 rules don't apply because there is no intermediary. There's no personal services company. There's nobody in between that individual and you. If, on the other hand, you are contracting with a person's personal services company, then since 2017, if you're a public sector body in the education sector, you have had to apply the IR35 rules, and from 2021 if you're in the private sector. And there was, of course, a little flurry of activity on that a few weeks ago. Do they apply? Do they not apply? Do they apply? Do they not apply? Well, we're back to where we are. We're back to where we were. It is still down to you as end user to sort that out, for the time being, at least until we get to the budget in a couple of weeks' time. We'll see what happens then. Something that some people quite often overlook, however, is what happens if you're contracting with an agency. The bottom point there is, as we've just talked about, if the agency is engaging with the individual through that individual's personal services company, then it's exactly the same for you in terms of what you have to do as it was if you'd contracted directly with that intermediary's personal services company. You have to apply the IR35 rules, you have to do an employment status determination and send it to that employee of that individual and their company. If, however, the agency is sending you one of their own employees, happy days, you don't have to do anything because those people are paying PAYE through the agency rather than through you. If the agency is providing you with somebody who is not their own employee, but who does not use a personal services company, then something called the agency rules apply, not IR35. And if that individual provides you with some individual personal services and you exercise supervision, direction and control, then there will be PAYE consequences, but not for you, for the agency. So important differences in terms of what your obligations and what your consequences are, depending on how you contract and how they contract down the line. So the important thing is to find out, particularly when you're dealing with an agency, find out who they're engaging and how they contract with them. So let's move on. Tax status, as Sian highlighted right at the outset, for tax purposes, there is no worker status. Tax status is either employed or self-employed. There is no definition of either for tax purposes, and the individual, helpfully, can have different status for tax and employment law purposes. Although I would suggest that if somebody is an employee for employment law purposes, they're going to be an employee for tax purposes. It doesn't necessarily work the other way around. I think you could be an employment status for tax purposes and be a worker, and that is quite a common outcome. So let's have a look at what the issues are. And as for employment status, as we've already heard, you have to consider all the relevant factors, but this isn't a weighing it up on a checklist approach. It's not sort of, if it's 6 of those and 3 of those, then it's you fall on the side of the 6. And the importance of individual factors does vary, and it is important to stand back and have a look at the whole picture. And I think importantly, status can change over time. And there's an example of this in the HMRC manuals. Somebody may come in to do some sort of consultancy project with you. That project comes to an end, and actually that person just continues. They move on to something else. It's quite obvious that that arrangement has changed at that point. Now, you could, of course, then contract with them as a contractor to do something else. But quite often that morphs then into a closer relationship, and you have to really have a look at how that might change over time. A lot of you will be aware of the HMRC CESS tool. This is the Check Employment Status for Tax tool. This is a tool you can use whether the person is an individual contracting direct with you or using their own personal services company. There are both options. The tests in terms of employment status are broadly the same. It came in for a lot of criticism when it was first introduced. It still comes in for quite a lot of criticism, but it actually does give you a pretty good steer. Unfortunately, with the CESS tool, quite a lot of the times, in those cases where you really need some help, it comes out with unable to classify this person. So at that point, you're then either falling back on your own view and making sure that you're happy with where you've come out, taking all the circumstances into account, or you go and seek further advice. So moving on, what do I think? You've heard about all the key factors, but what comes up time and time again? What are the key things when you're going through, for example, the CESS tool? What tips it one way or another for employment or self-employment purposes? the get out of jail card, if you want to look at it like that, is the requirement for personal service. You cannot be an employee for tax purposes if there is no requirement for personal service. So if what you're buying is an end product and you're not bothered about actually who delivers it, then that'll be clear both from the surrounding facts and from the contract. And we'll have a look at that in detail in a second. The second is classically control. And control, the importance of control varies in different situations, how expert the person is, whether you'd exercise control over how they do something or just provide a framework of control. So we'll have a little look at that in a moment. And the third one is business in their own account, on their own account. One of the things HMRC do is they'll see whether the person's got a website, for example, how they describe themselves to the outside world. Usually with the in business on their own account, you know it if you see it. And there are some very obvious examples. If you're engaging a plumber to come in and fix something and then go away, that person is clearly in business on their own account. But then, there are obviously a lot more grey areas. So I'll have a little look at that as well. So those are the three areas that really tip the balance one way or the other. So let's have a closer look at personal service. So as I said, is there a specific person you're engaging to do the work? We always, if we're dealing with a client who's contracting with somebody and they very much feel this is what they might call outside IR35 or outside employment status for tax purposes, we will always try to suggest to them they don't contract to ensure that an individual is doing the work. Obviously much easier when you're dealing with that person's company rather than the individual themselves. But they're suggesting that the work is done, but not necessarily who does it. So they're contracting with somebody for something to be completed, not necessarily who does it. But it's necessary for this to stand up, for there to be an unfettered right to send a substitute or delegate. And Maya already mentioned the substitution provision. So the revenue will look at whether the engager has a right to refuse, and that would not then be an unfettered right to send a substitute. They'll also look at whether the right's ever been exercised, or whether it could be exercised, whether in practice it's a practical right. There was one of the most high-profile cases on the tax side as concerned TV and radio presenters, and it was decided there that although there was a right to send a substitute in the contract, really that wasn't really that really wasn't ever going to be exercised because it was the person they wanted. So what if the worker's unavailable? What happens, and does it actually happen as I've put there? So looking at the second key issue, and control over what's done and how it's done. As I said, if the person's an expert, then control over how it's done is probably less relevant. Famously in their manuals, they give the example of an airline pilot. And the minute by minute control over that person's activities is down to that person. It's not down to anybody else. But there's a framework of control in terms of who sets their schedule, who sets their days. These days less important where, because obviously with home working, it's we've got clients who actually don't specify to any of their employees or off payroll workers where work must be done. The most important thing here latterly has been ability to move the person to other tasks. So if somebody's contracted to come in and do something very specific, and at the end of that they stop their engagement and they go off and do something else for somebody else, or indeed they do something else with you but under a separate contractual arrangement, and that might indicate that they're self-employed. If, however, somebody comes in and you just sort of say, well, go and do that, and then when they finish that, you say, well, now go and do this, and they finish that, and you now go and do this over here, or even concurrently doing things at the same time, then that points far more towards somebody who is in control of that individual, and they take a lot of notice of that. And then the third element being in business for yourself. These are sort of fairly obvious, really. Has that person got lots of clients? Do they do work for a number of different organizations? That would tend to indicate that they are indeed self-employed for tax purposes. How integrated are they in your organization? Do they manage anybody? Are they managed by somebody? So that goes to integration and also to control. How are they described in the internal websites? Do they have their own website, as I've already highlighted? What would be the perception of people both within your organization and externally? How would they present themselves? And linked to this, do they have an ability to profit because of the way that their remuneration of their consideration for the services they're provided has been calculated? Is it just a set fee? Is it a daily rate? Most often it's a daily rate, and therefore that element takes less headline profile. Now have a look at the next one. So what are your practical issues? And it's really most important that you've got visibility on who your off-payroll workers are, and I'm sure, as some of you will have experienced yourselves, I think the biggest issue that a lot of employers found when all these rules came in was they didn't have visibility on who all the off-payroll workers were. They were engaged by all different parts of the organization, not necessarily through the HR teams, not necessarily even through the procurement teams. They'd be done fairly randomly. So the first exercise always to do is to know who your off-payroll workers are and the arrangements under which they work. Make sure you've got the contracts. Make sure you've got a robust process for assessment. In most of the cases that you'll come across, you will need to do an assessment, and in some of those cases, you will need to provide that assessment in a written form to the individual or their company if they're using one. And if you're dealing with an agency will often ask you also for your own assessment of supervision, direction, and control, which is slightly different. You'll also need an appeal process, as you probably know, if you're dealing with IR35, not if you're dealing with the other issues. Make sure you have a good look at your contract. If you're contracting on your terms, of course, that's great. Happy days, because you've got control over what you put in there. Your indemnity provisions. Of course, it's a little bit difficult for you to be indemnified for your own default if you're assessing somebody as self-employed and that proves to be wrong, and you have the tax obligations. Might be quite difficult to then enforce those against the individual, but worth having them in the contract. As I've already highlighted, as my colleagues have highlighted as well, of course, if somebody thinks they're self-employed but you disagree and you think they're an employee for tax purposes, you will have to exercise payroll, but that's likely potentially to have a knock-on in terms of their employment status. It might not. If they're using a company in particular, it probably won't. But if they are contracting with you individually, then that is something you'll need to consider as well. And of course, the impact on business models. When all these rules came in, that was probably the biggest issue, because it was quite obvious to some organizations that the way they had been doing something was going to give them some problems, was going to give them some tax liabilities, and therefore they decided to change things completely. And perhaps the biggest issue we're seeing in practice is that last point. We're talking to organizations and clients who say, well, we're doing this right, but our competitor up the road isn't. And therefore, all the people who we want to bring in on an off payroll basis, but feel we can't, are all going there. And as a result, we're not able to provide some of the services to our clients and customers we would like to. Right, I think Sian's now going to pick up some other practical issues generally.
Thanks, Kevin. I think, yeah, definitely the battle for talent is something that the sector's seeing, particularly with interim roles, and IT. We're talking to a lot of clients about that, that looking at models and how they engage people with those particular categories. So just looking at practical tips generally, beyond the tax specific perspective. So there are some probably key questions that we're talking about and have done with clients that are worth you considering. So first of all, what does your workforce really look like? The sector has relied on flexible resource, whether it's hourly paid lecturers, visiting lecturers, or postgraduate teaching assistants, which are also students, and various categories. And over the years, they have increased in volume, and the reliance has become greater. And so therefore, some universities are thinking this is a massive can of worms that I don't want to open. Some have started to open it. And so it's really worth looking at the whole of your workforce and what it looks like, and making sure that you consider how you can retain and improve your agility and keep the flexibility of the resource, but also bearing in mind the campaign that's ongoing in terms of against casual work and ending precarious contracts, and ensuring that you're compliant with your legal obligations. And so a few points to consider. We'd encourage you to review your existing arrangements. So looking behind any contractual documentation that you have with particular individuals, particular service companies, if it's personal service companies, and look at what individuals are doing in practice. So what Maya talked about in terms of what's actually happening on the ground, both in relation to control, mutuality of obligation, and actually the practicality of the arrangement between the institution and the individual. What does the relationship actually look like? How is the individual integrated into the workforce? And is it akin to an employment relationship, comparing it to other employment relationships that you've got in the organisation? Or is it a worker relationship? Or is the individual actually conducting a business on their own account, and the university is a client of that individual's business? And it's worth auditing current workers. I don't necessarily mean audit in a tax or accountancy way, but it is worth looking at and breaking down all the different categories of workers and that you engage with in order to correctly assess their employment status, and both for employment and both for tax purposes. And again, if this feels like a can of worms, which it does for some organisations, then it's worth prioritising the larger categories of workers, so those that aren't treated as employees currently, that the universities use and that may have a greater liability. So it could be those hourly paid lecturers that you're currently using, depending on how many you use, and phasing how you're going to audit and implement any changes in relation to them in the way that you engage them. And that may involve working with relevant colleagues who may engage workers directly. So it might be faculties in departments who ring up Joe or Lucy because they teach a particular module, and they ring them up every year, and it might be for 2 weeks a year. So it's not necessarily HR or procurement or your finance department who might be directly engaging workers, depending on how your organisation works. And then it's worth considering the status of how you engage new recruits. So not just looking at your existing workforce, but how you're engaging your new workers, to consider that they're carefully assessed to be correctly engaged in terms of their status. And so that will minimise any risk of future liability because of their an incorrect assessment of status, both for tax and employment purposes at the outset. And then it's worth assessing liability issues. And I always say to clients, doing this behind closed doors. And so when there's pressure from the unions, and for example, in relation to back pay, dare I say Brazil and holiday pay, it's worth getting your house in order to find out what your potential liability is before committing to anything in terms of back pay, and perhaps drawing a line in the sand to arrange, this is how we're going to treat holiday pay going forward without any commitment to anything going backwards. But in order, before you're doing anything openly with the unions, it's worth knowing what your potential liability could be in relation to incorrect assessment of status with various categories of staff. Again, phasing in accordance with the size of that group of staff and potential risk. And Brazil is beyond the scope of this, but again, it's another reason which has meant that the sector is looking more closely at this category of workers and staff, which it has relied on heavily in the past. And so it's another reason that this category is under increased scrutiny, and the sector is under pressure to audit and assess the status of its staff to make sure that they're getting the correct rights, they're getting the correct holiday pay. And so, as this session has demonstrated throughout, it's complex. There are various different factors. It's very case specific, and the lawyer response, it depends, does really apply to this. And so there are various guidance that you can apply, but it's worth seeking legal advice as necessary. In relation to your audit, if you are carrying that, your assessment, but also in implementing any changes that result from that assessment, if you need to change the way that you engage workers in order to minimise any future liability for your organisation in the future, whether it's in relation to holiday pay or tax. We haven't had any further questions, but feel free to put those in now if you do have any. Otherwise, thank you for joining.